So we're going to try and do a video which broadly takes us through the criminal sort of cycle from beginning to end, looking at the case ratio workflow and really trying to identify as many of the compliance issues as possible along the way, just to show you how case ratio supports us hitting those sort of compliance obligations with the minimum of fuss, and how they're kind of built into the system. So just an overview of beginning to end and touching on some of the compliance stuff along the way. So the starting point of our story is a police station interview, and predominantly we would open these files using case ratio offline and a police station booklet. And within the police station booklet we would capture various pieces of information, including importantly things like the DSCC reference number to enable us to build the file, but obviously also details about the allegation. And then just to pick up on the relationship between the case ratio offline booklets and the case ratio online system, there are certain paragraphs which will go directly into the templates when you generate letters from case ratio online, and these are marked within case ratio offline usually by an asterisk because they're usually mandatory fields, but you can also see the instruction that these paragraph letters, these are going to go directly into the content of the template when you generate it. We may or may not need to do a legal aid application, in which case we can put information about the client's financial situation in here. We'd always have to do an outcome. Here I've just going to take this police station on the basis that it was concluded as a released under investigation, and then time, and let's go into the correspondence tab. So in the correspondence tab are a number of questions which relate to our compliance obligations. The first relates to whether or not there is any particular risk on the file. Risk can be interpreted subjectively, a risk of complaint because it's a difficult client, physical risk to your health because of the kind of client, and we need to treat them carefully. Anything to do with, say, mental health issues that you want to flag up, etc., etc. So it can be interpreted quite broadly. If you answer yes to this question, you're obliged to give additional details, and those details are passed to the risk manager by email automatically. Another compliance question here: quite often we have the situation where we are authorised to deal with third parties, and here is the opportunity to capture that information, and this information will then appear on the file cover in the warning notes tab in the case ratio online case. And finally we've got the conflict of interest question, and in here we would make our best assessment of the current conflict state. We won't have had a chance to do any kind of database search, but you'll know, for example, if you're at the police station dealing with co-defendants, but the majority of time, it will end up being none of the above. With all of the mandatory information completed in the case ratio offline booklet, including the relevant information dealing with our compliance obligations, we should then be able to finish this booklet, and that's the first part of the process. This will then send the file to be opened on the case ratio online system, which is where we'll pick up the story next. So here we're on our file, which has been opened on case ratio online following the upload of the booklet from case ratio offline. And to just pick up on some of the compliance matters we've been talking about, over here in the right hand corner it refers to being high risk. We can click this button. We can see that it's indeed been marked as high risk and given the details of the particular risk. It's also got details of the current state of the conflict of interest under there as well. In addition, on the warning notes, we can see that we've got the details of the risk again, and also the additional information about being able to speak to a third party on the file. On the history, we'll see a copy of those notes. So we've got this warning note here. We click the history properties, we can see this is dealing with the issue of the conflict. We've also got another entry here confirming that no conflict identified at this time, and this warning note will relate to the risk. And we've got the police station booklet. And then the next part of our compliance obligation is to deal with the client care letter. So every time we have an attendance, we follow up with a letter. Every time we upload a case ratio offline booklet, it will create a schedule item in the case ratio online case, and from that schedule item we can click and it will create a template which is relevant to the particular circumstances of the case. So relevant to the circumstances of the case, what does that mean? Well, this is the beginning of the matter, so we need to set out obviously the details of the particular attendance, but also we need to enter into the retainer with the client and send them our terms and conditions. So the point of using the schedule item to generate this template is that it will generate templates which don't just relate to a particular letter. They tend to generate content which relates to a process. So in this case, I'll go through this letter and we can see that this is text that's come directly from case ratio offline, as is this, as is this, but the template is otherwise assembled from the database information that we provided. But because of the particular stage of this case, it's also bundled up the terms of business with this letter to go to the client. So the computers recognise the fact that it's at the beginning of the case, and therefore in this situation we need the terms of business to go with the letter. If the matter was NFA, it would also bundle up the closing letter. So we would end up with the client care letter, the terms of business and the closing letter. Obviously that's not relevant in this case, as this matter was released under investigation and so it's ongoing, but the point stands that the computer will bundle up the documents you need. So in this case I'm going to move this matter on the basis that this client has been charged, because the next part of our workflow and the next part of our compliance obligations will really relate to what happens at the first appearance. So I'm back in case ratio offline because the next part of this process is the attendance at the first appearance, and again within the case ratio offline booklet we'd expect to see various bits and pieces which both feed into the letter and tick the boxes with regards to our compliance obligations. So I'm going to skip through this in large part and just focus on those aspects. I'm going to add an outcome, and in this case the outcome I've added is that we're going to adjourn this to a PTPH. Under the letter paragraphs, here's where we get some additional content for our template letter. So here we know that jurisdiction was resolved. We've got, let's say, an either way that was sent, and we've got then paragraphs in the letter: you were charged with, you instructed me that. Before going into court, the strength of the evidence was, and then this is an additional paragraph that you can add to the letter if you want to provide additional information. For example, we discussed the fact that you would need to provide, with regards to either evidence or financial information. And then the next part of our compliance obligations comes under the correspondence tab. Again, we repeat the trick with regards to the risk, so either yes or no, and then details if yes. Again, about conversations with third parties and the information, and again the information, updating the information regarding conflict of interest. So provided we captured all that information, then hopefully we should be able to upload the first appearance booklet, and with that uploaded we'll go back to case ratio online for the next part of the process. So back in our case on case ratio online, we can see on the file cover that the risk has been updated to low because that's what we put in the first appearance booklet. We've still got the warning notes on the file cover. We didn't update any in the first appearance booklet, so they're the same. In the history, we can see that we've got the booklet. We can also see that we've updated the conflict from the first appearance, and we've updated the risk from the first appearance. And then on the schedule, we have the schedule item for the template letter. Remember, attendance letter, attendance letter, attendance letter. And here is that letter, or rather here is a template that has been prepared by the system based on the inputs. So here we have the text that came from the booklet relating to the particular allegations. Here the text from the booklet relating to the instructions. Here the advice about the strength of the evidence, etc. And then some database text relating to the fact that in this case we said the client was on unconditional bail. Picks up a paragraph about where we are on funding, and then, as we've discussed previously, We then have information which is relevant to this particular case based on the inputs. So because this was adjourned to a Crown Court case, there's an additional Crown Court leaflet here. If it had been adjourned to a Magistrates Court trial, this would be a Magistrates Court leaflet. If we had not previously represented the client at the police station, it would have bundled up the terms of business, but in this case it hasn't done because this client has already got the terms of business, so all it needs here is the letter and the Crown Court proceedings leaflet. So obviously that template is capable of being amended when you run it within Case Ratio Online before you close it down and then send it to the client. However, it will help you in terms of making sure you've got the correct additional information by way of, in this case, the Crown Court leaflet, having already picked up the other compliance obligations regarding risk, conflict, etc. When a file has gone beyond the first appearance, we also need to think about the fee earner on the case. We tend to default files into the name of a default fee earner at particular stages. So when we start a police station file, or when the matter moves to Magistrates Court, either because it's charged or is opened at the Magistrates Court stage, because it's a new file for us at that stage. Once we've moved from the first appearance, we then need to allocate the file to a particular fee earner, and when we allocate the file to that fee earner, we also need to notify the client of that allocation. So just to run through that again, on the file cover we would click fee earner, we would remove the name of the default fee earner, update the fee earner to the person that we want, and then that will prompt us to send the allocation letter, which again is a template which can be amended, but by default will pick up the name of the fee earner and should also include the name of their supervisor, which is the other part of the compliance obligation here, that the client should be notified of the fee earner and their supervisor for the purposes of any complaint. So once that's completed, we can save and send to the client in the normal way. Okay, so time to go back to Case Ratio Offline as we then take the next step, which is the attendance relating to the plea and trial preparation hearing. Okay, so we're going to whistle through the Crown Court booklet. Again, there's a letter paragraph section, an outcome section. Here I've adjourned the matter for trial, a bail section, and under the correspondence tab, again, we've got the question regarding risk, any information about discussing with third parties. But interestingly here, we don't have the conflict questions, and I will explain why in a minute when we upload this and we return to Case Ratio Online. So when we return to Case Ratio Online, we'll see our file cover is updated. We've still got low risks, as that was the risk assessment from the PTPH. We're building up the attendances on file. We will expect to see in the history. Slightly confusing here because I've done the video on the same day, but this is the Crown Court booklet and this is the risk assessment relating to the Crown Court attendance. And then on the schedule, we've got the letter relating to the Crown Court hearing outcome. Okay, and looking at the template for the Crown Court hearing outcome letter, we'll have some content that's come from the booklet. We'll have a paragraph relating to bail. We've got a paragraph here relating to the instruction of counsel, and still a funding paragraph also. No terms and conditions here, no further leaflet, just the structure of a letter which is appropriate for the position post PTPH. And let's just pick up then on the issue of conflict on Crown Court cases, because we saw that the question relating to conflict wasn't in the Crown Court booklet in Case Ratio Offline. And I suppose it's also a chance to reflect on who would be involved in these processes at different times. Obviously, the way we've structured this video, I've done the booklet, I've done the letter from police station, mags and Crown Court. However, in normal circumstances, the workflow is set up on the basis that a rep would attend the police station, and predominantly the letters are run by the administration department and the letters are set out in the third person. We advised you that. Then we go to the magistrates court stage. The workflow is set up on the basis that, as a rule, the person who attends the hearing, the advocate at the hearing, will also end up doing the letter. That doesn't need to be the case. Somebody who attends the hearing as the advocate could then pass the letter on to be dealt with by someone else who's managing the preparation of the file, but those templates are set up in the first person. I advised you that. When we get to the Crown Court, we're very much set up on the basis that the advocate and the person preparing the file, the litigator, are very much more likely to be different people. And so when we schedule the letter to be done after a Crown Court hearing, the assumption is that the letter will be run by the fee earner on the file as opposed to necessarily the advocate who attended the hearing. That's different in the Magistrates Court. The system is set up so when the advocate attends the hearing, the schedule puts the schedule item in their name to run the letter. So police station, rep doing the attendance, and then the letter usually done by the admin department. Magistrates Court, attendance by the advocate, schedule item in the name of the advocate, but ultimately it doesn't really matter who runs the letter, it can be a different person. In the Crown Court advocate does the booklet, schedule item goes into the name of the litigator on the file, and then the litigator is also responsible for keeping up to date with the conflict of interest position on the Crown Court files as well. And here on the file in the schedule, 6 weeks after the PTPH is a schedule item to just update the conflict of interest check. Not a very difficult thing to do. Click. If there's no reason to update the conflict of interest position, we can just click no and OK. It will then reschedule for the conflict position to be checked in a further 6 weeks time. In a further 6 weeks we could just click again. Again, if there was no need to update the conflict, we could do no. If there is a reason to update the conflict of interest position, we will end up with a situation where we're asked to prepare an attendance note, and in the attendance note we can explain why we're updating the position in relation to conflict of interest, and then we can just save that back to the file. So then on the history, what we'd expect to see here, the conflict of interest, no update. Here on the second conflict of interest, we've updated, see attendance note, and then we've got the attendance note relating to the updated position with regards to conflict. So if there's no update, we've still got this audit item, and if there is an update, we've got the separate attendance note as well. So those processes run throughout the Crown Court file and help us just maintain the visibility of our conflict checking on those files, but pretty straightforward in terms of the amount of work involved, but it makes the files very audit friendly. So let's try and get to the end of this story. We come back into our Crown Court booklet. In this case, the Crown Court advocate would add any content to the paragraph that we hope to go into the template. The outcome here I've added as sentenced. I put some sentence details in, and then finally under the correspondence we expect again to have to update the risk assessment before we're able to upload. So we get into the final phase. The case ratio offline booklet has been uploaded and the file cover has been updated to sentenced. As we'd expect on the history, we've got an update to the risk assessment, we've got a copy of the advocate booklet on the history, and in the schedule we've got a schedule item relating to the hearing outcome, and the next part of the process, the closing letter. So again, dealing with our compliance obligations, once we've got to the end of this case, we obviously have to provide a closing letter in addition to the outcome. Just quickly also pick up the fact that up until now, the pre-letter questions had been asking if we could send the letter by email, to which I'd been answering yes. This unfortunate individual has just been sent to prison, and that's why we're now being asked whether it can go by post and whether or not we want to assign it to the central print tray or not. So our template letter has got some content from the letter paragraph section. It's got some details about the custodial sentence that was imposed. In addition, some details about the additional financial penalties that were imposed. It also brings through some additional details that I asked them to add from the booklet. It also adds a section on appeal, and again the advice on appeal that came directly from the booklet. Funding is only still here because I haven't updated the file properly to reflect the fact that funding had been granted, otherwise that would have disappeared long ago, and confirmation of file closing. And then here in addition is the closing letter, and part of our obligation also to send out the client satisfaction questionnaire. So again, the computer has recognised the stage in the proceedings, it's done the Crown Court hearing outcome letter. In addition, it's bundled up the closing letter and the questionnaire. And then we've got the closing risk assessment and the closing conflict. So that deals with those compliance obligations as well. Then it will start to push you down the path of the billing process, and this is true in Magistrates Court or Crown Court. The Crown Court obviously a slightly different process. If you are not ready to bill the file at this stage, you can click out of here, but then assuming you are ready to undertake the billing, it will ask you another series of questions. The first in relation to transfer of legal aid, secondly how many defendants we represented in the case, are we seeking to make a claim in respect of any pages served in digital format, and are there any outstanding invoices that we haven't already processed through the file and paid the experts. So that's just a flag that there's some unpaid disbursements still on the file. Then we get the instruction to destroy any hard copy paperwork, make sure anything is scanned to the history, send any physical disks relating to the case to the billing department, remove any copies you've got from the local storage on your device. Yeah, when we get to the end of the case, we really should just be centralizing everything onto the case management system, removing everything from any other places where the information is stored. And this is just saying that, you know, the obligations under the GDPR are deletion by default. We will delete this information after 6 years when it's on case ratio, but we shouldn't have any other copies elsewhere, which would then sort of nullify the fact that we are going through that compliance process. And here's just confirmation that we've completed the billing process. When I update the schedule, we'll see that now the job of billing the file has been passed to the billing department. So that's your involvement in the billing of the file. And that's your involvement in the case. So we've gone from police station to MAGS to CROn. We've done attendance letter, attendance letter, attendance letter. We've kept the risk updated throughout the case. We've kept the conflict updated throughout the case. We've dealt with the issue of allocation, and the structure of our templates has been appropriate for each stage of the case, and at very least giving you this structure, if not 100% accurate content in terms of the information that the client requires at those particular times. So hopefully that overview of the workflow you can keep in mind when working through other cases. Obviously there's a lot more going on any particular case, but that's the sort of overarching workflow that underpins it all. So that's the workflow on Case Ratio Online.